It is Thursday, which is a mini Friday. It is 10 a.m. and it is not sunny in New York. Um, so I hope there's going to be joining us today. We're going to talk about something interesting and something we definitely get a lot of questions about, something that a lot of our clients care about a lot, which allows them to support their families here, have a form of ID, get a driver's license, and so on and so forth. So we will talk about work authorization. Before that, I just want to report from the front lines. Um, a lot of embassies around the world remain closed. I understand and I sympathize. A lot of families are torn apart or they cannot reunite, or people who thought that it's going to take a few months to bring their loved one. It's now, taking years to do so. There is nothing anybody can do about it. The embassy, if the embassy is not interviewing cases because of the COVID numbers in that specific country, you can't change that. Sometimes an embassy will reopen interview a few of our clients, and then the numbers will go up in the country and it will either suspend its services or will definitely slow it down a lot. We have been successful in getting some cases expedited. It is a case by case basis. They will need documentary proof. So, like, I miss my husband. I really want him to be here. Unfortunately, is not going to qualify. But if you want to talk about potentially expediting your case, only if the embassy in the country in which your husband or wife or loved one or employee um, is open, right? Also, this is a big note for everybody. If a person has already attended an interview at an embassy and then wasn't able to get the passport with a visa because of COVID, because the embassy shut down, and the only thing that's outstanding is like a second interview or like a piece of paper or something like that, we can't transfer it to another embassy. It's also not in their best interest to do so because they already attended an interview. An officer already looked at their case and they're most likely are, this close to being approved and coming to the US, but for COVID numbers. That takes care of embassies. As the numbers go down and vaccinations go up, we're hoping, to see a reopening. We're definitely are anxious to see a reopening for a lot of the European countries. People have been stuck for quite some time. So that takes care of embassies. Now, in terms of immigration court in New York remains closed through May 14th. That means if you have a hearing scheduled, it's not going to take place. You can definitely follow up with us, but we sent out an email and we call you, we'll let you know that your hearing is not happening until at least May 14th. We don't know, and I strongly suspect that the immigration doesn't know itself whether they will reopen after May 14th or when they will reopen. For example, a immigration court that's very near to us, which is Newark, where we go a lot, does do video phone master hearings, but a lot of those also get suspended because the judge will just issue an order saying this is what I want from you by this date, and then they'll just postpone the case. It is not always a bad thing that your case is getting, postponed. Some people whose cases were supposed to be in 2020 are now going to be having their hearings under a new administration, and in a lot of ways it can potentially benefit them, the fact that they kind of were saved by COVID, or their cases were postponed due to COVID. That takes care of immigration. We don't know ahead of the time when your next hearing is going to be scheduled. Sometimes your next hearing is not set until like weeks after the canceled hearing was. Both the client and us get a notice in the mail of the next court hearing. There has been a lot of switches between judges. So just because you had one judge pre-COVID, so to speak, doesn't mean you're staying with them. There has been a lot of new judges, and there's been a lot of like reassignment. Again, it remains to be seen in your specific case whether it's going to be good or bad. But just, give us a call. We'll answer any questions that you have. So this is on immigration court because a lot of people are anxious and understandably frustrated. USCIS, which is the immigration agency that takes care of green cards through marriage, adjustments of status, naturalizations, I-130s. They are working. Yay, someone's working. They're working, they're busy, they're scheduling a lot of interviews. Sometimes we have to be there 3-4 times a week. They are approving cases without any issues quite fast. Sometimes we walk out of the building and the case has already been approved, and in a week the person already has their green card. They are being extra cautious with the medical exams, understandably. Also, just because you had a successful interview, there is a human factor to it. Not every officer approves things the same day, nor are they obligated to do so. There's some officers who are, slower in pace and like to cross their I's, dot their I's, and cross their T's. They do have 120 days. Now, if 120 days have passed since the time of your interview, we can start submitting inquiry. If we submit an inquiry within that 120 days, it'll just tell us that it's within what's called a normal processing time. It's not going to, allow us to expedite or do any sort of inquiry on the case. But we see majority of the cases, well over 90% approved in the first 120 days, sometimes same day, sometimes in a week. There's a very, very small percentage of cases that remain beyond the 120 days, and that's when we can actually, write letters, submit electronic inquiries, and even do like an info path at some point. So that takes care of that. Now let's talk about work authorizations. Work authorization, EAD, employment authorization, is a card that has your A number, your picture on it, date of birth, and allows you to work for any employer in the US. And this is true unless you are in one of the employment categories, which I'm not covering here. This is for work authorizations that are issued under, let's say, adjustment of status through marriage, or issued under DACA, or are issued as a part of an asylum case. This does not cover more complex employment investment type situations. Okay? So, first of all, in August of 2020, under the previous administration, the rules have changed for asylum seekers only. Before, if you applied for asylum from the date that the USCIS has issued a notice, your receipt date, after 150 days, you can submit your original work authorization application for work authorization, attend the biometrics, and get your work authorization relatively quickly. The first work authorization application was free, and then you had to pay the filing fee and the biometric fee when you had to renew thereafter. The very first thing that we saw 4 years ago, pretty much, is that they way slowed down the processing of the work authorization. So people were stuck not having work, like let's say you applied 150 days after, it would take 30 days to process. That would bring you to 180 days, which was, your statutory eligibility. But then we saw 6, 7 months in processing. So that would effectively not give you work authorization for a year, basically, even though you complied with everything and you submitted everything in a timely manner. The USCIS just took forever to issue them. And that brought us to the next subject, because the people who were getting these work authorizations for a while, because their asylum cases have been pending for a while, were used to coming to us like 30 days before it expired. They bring your 2 passport pictures, your filing fee, your attorney fee, sign everything, review the application, we mail it out, biometrics, done. That is not the case now, and we strongly encourage everybody to contact us more than 6 months before the expiration of your date of your work authorization, because they are taking a long time. Even just to get a notice that your case was accepted by USCIS recently has been taking more than a month, sometimes 2 months. Sometimes they get lost by USPS. We've had those issues as well. So if your work authorization is good for a year and you have to come renew it 6 months before it expires, obviously, it puts a burden on our clients. And that has to do with processing times only. If you want to make sure that you at least have the letter that extends your current work authorization for an extra 6 months, you got to come to us way in advance, 6 months before your current work authorization expires. So how does this work? Let's say your work authorization expires January 1st. You come to us June 1st, which you should come to us May 15th, let's say, so that we make sure that everything is there. We have the application ready to go. Most of them we can prep and send out the same day. Just in case, give us a call, 2 weeks in advance. When you submit the work authorization application and it is accepted by USCIS, you will then get a letter from a USCIS on a thick green piece of paper that will say, this is the receipt notice. And on the middle portion of it, it'll say that this piece of paper extends the validity of your current work authorization by 6 months from the time of its expiration. So essentially, if your work authorization then expires January 1st and you still don't have the card, you can continue to work with that thick piece of green paper. And you're going to be okay. You're allowed to do that. The piece of paper says in it that, the EAD has been extended for a period of 180 days. That is very, very helpful. We have had cases where work authorization took 8 months and the person didn't have to lose their job because they had proof that they can continue working even though they don't have a card. But in order to take advantage of that, you cannot wait for your current card to expire before you file a new one. You have to be diligent and on top of that. Now, it becomes kind of tricky when you're adjusting status based on marriage, because theoretically you're thinking, we'll go to an interview, everything's going to go great, and then I'm going to get my green card and then I won't need a work authorization. But first of all, COVID. So just because you're scheduled to attend an interview on April 1st, it is not guaranteed. What if the numbers spike and the interview is extended by 30 days or 60 days or whatever? Or what if not everything goes great in interviews? Those are not guaranteed. You don't know what kind of questions, whether you're going to be prepared. What if the doctor made a mistake on a medical? What if the officer is going to say, well, I want this additional document? What if the officer is going to take the 120 days to review your case, which they can? And then if you're work authorization expired, you don't get an automatic extension. You have to come to us, bring 2 passport photos, payment, signatures, review of the application, send it out. So although it puts additional burden on you, but it is beneficial to have it, especially if your work authorization is together with a travel document. Um, and that's a separate issue that we can talk about next time. So that has to do with processing times. Processing times are long. USCIS is backed up. It takes them a while to even send an acknowledgement that the case has been accepted and is processing. There are no um, easy ways to expedite it. It has to be some sort of true emergency. But for the majority of people, nothing will get expedited. Sorry about that. Nothing's going to get expedited. So just know those times, and those processing times. We're hoping that as COVID slows down and we're returning back to more regular processing times, we'll go back to the days when it's issued in under 3 months. But for now, that's not the reality. Now, I could talk about this all day. Now, let's talk about work authorizations specifically for asylum cases. This next section is going to be for those people who only have pending asylum cases. Let's say you're in this country, you filed your asylum within the 1 year, everything is great. Used to be that you can apply after 150 days. That has changed in August of 2020. You now have to wait a year before you can even apply. So it's not like after a year you get your work authorization. After a year you can apply. There are other qualifiers in it. There's a difference between being caught at the border, arguably, and having presented yourself at the border to seek asylum. Another change was that now the first application is no longer free. You now have to pay $85 of the biometric fee, even with your first application based on asylum, after having waited a year to do that. There is a settlement out there. I'm not going to bore you with the names and stuff, but 2 organizations sued the administration, and in their settlement, if you are a member of the organization at the time of filing your application for work authorization, you can file it before the year is up. You don't have to pay $85 biometrics fee, and the USCIS has to process it within 30 days. But you do have to wait the regular period of 150 days before you apply. So if you are a first time, if you're an asylum seeker and you're applying for the first time, this applies to people who haven't had work authorization before, based on an asylum, definitely give us a call, because there are rules that are new, and there are exceptions to those rules. Okay, highly specific. Takes a 5-minute phone call, but just need to know the details of your specific case. Now, I know people don't like to hear that, but I am going to say it. Work authorization is not a right. There is no guarantee. It's not a right in terms of it is not a right under our immigration laws. It is more of a discretion. It is more of the U.S. government saying like, hey, we know this is taking a long time. Here's a way to support yourself. but there is no guarantee to your work authorization under our immigration laws, um, in terms of just being here, entitles you the ability to work. It just doesn't work that way. I know that it might not be fair and it not might be the right way, that people have to support themselves, but that is the way, that it is. And I'm going to say something which I have been seeing a lot lately, in our clients. Be very careful. There is no circumstances where a person can just go and get a work authorization without having something else pending with USCIS, with the immigration court, with ICE, or something like that. The work authorization, and we're talking about excluding employment cases. We're not talking about employment-based situations right now. We're talking about people who are in removal proceedings, seeking asylum, getting green cards based on status, or being relatives of U.S. citizens, DACA kids, certain ICE, deferred actions, and so on and so forth. You're given a work authorization in conjunction with something else that is pending, whether it's a green card application, whether it's asylum, whether it's your DACA status, whether it's your temporary protective status. There is something in the work authorization, that there is something pending that gives you the right to have this work authorization. Gives you, not the right, I'm sorry, the ability to have this work authorization. There are codes on the work authorization, C9, C8, A10, that tell an attorney, or even you, because you can look them up online, what it is that is pending with an immigration, agency, based on which you obtain this work authorization. So if you go to someone who says, sure, work authorization, how many? No, no, be very careful. That is almost always not the case, always not the case. Okay, you have to be careful and do your due diligence, because if it sounds too good to be true, and you've been in this country for 20 years and you've never had a work authorization, and all of a sudden this person says, sure, work authorization, sure, social security number, that should raise a red flag in you specifically, because whatever is going to be filed with USCIS, you will be signing. You will be on a hook for those applications. Especially there are multiple ones, especially if you're traveling with them, that all becomes extremely, extremely complicated. On a bright note, what is the bright note? What is the bright note? The bright note is, if you need a work authorization, you're working, which is already a good thing, right? Because so many of our clients have not been working because of COVID, and I'm glad to see people returning back to the workforce, returning back to their regular lives, and an increase of even needing the work authorizations, because that means, things are happening, and we're happy that they're happening for you. But we just want you to be careful and diligent, and and immigration law is second in complexity only to the tax law in the United States. It is highly specific to the facts of the person. It is highly specific to certain timings. It is very individualized. And when you compare yourself to other people, my cousin did this, his aunt in a third degree did that, even one little difference in the case, could have allowed them to do something that you can't, or allow you to do something that they can't, right? So just be very careful about when you're talking to people about these things. They might seem the same, but a lot of the times, they're not. We will find a difference which enables them to do something, or you to do something which they can't. So I'm going to sum up on the work authorization. Processing times, long. Make sure you start the renewal at least 6 months before the expiration of the current work authorization. Yes. You will have to do biometrics for your work authorization and pay a biometrics fee. Definitely. If you're received a interview notice and it's a green card based on your relationship with a U.S. citizen or a green card holder, such as marriage or being a parent of one, and your work authorization is about to expire, you should still renew it. And I forgot to say that, but this is very important. Let's say you have a green card pending based on marriage. And let's say you have a work authorization that is good for 2 years. And let's say something happened and the actual green card application was denied. Let's say it was denied March 1st, but the date of expiration on your work authorization says February 15th, 2022. No. If your underlying green card application was denied, your work authorization is no longer valid. It ends, the permission to work ends, if you don't appeal, because you have 30 days to appeal or refile, whatever the case may be. It ends on that day when your green card was denied. It doesn't continue to be valid just because the date on it says a year ahead. Why? Because your work authorization is based on the pending green card. It is never a standalone application. All right? A lot to digest. Send us questions, comments. I can revisit this topic if it's interesting to you next week. Just send us something that I know that this is interesting to you. Maybe there are some specific questions that you want me to expand on. I will happily do that. I have been talking for 30 minutes, not surprisingly. I wish everybody a great week, a great weekend. I hope the sun is going to come out and shine on us. Continue to be healthy. Continue to, vaccinate and practice social distancing so that we can come out of this sooner and better and stronger. I can't wait to see everybody next Thursday at 10 o'clock, and I will tell you what we're going to be talking about probably around Monday. It was great to see everybody. Have a great day.